Welcome back, everybody, to our studies in criminal evidence. So in the last lesson, we introduced the topic of witnesses for the study of criminal evidence, and we thought about the question of competence, whether or not a witness may or may not be competent to give evidence in a particular trial. And we noted in the previous lesson that, generally speaking, and as per the Youth Justice and Criminal Evidence Act, section 53, it is generally presumed that every single person who could be called as a witness will be competent to give evidence at all points within the criminal trial. The presumption is in the positive. The presumption is essentially a presumption that everybody is in fact competent. It is then up to the parties or the court to maybe challenge that presumption, to rebut that presumption by questioning whether or not they are in fact competent to give evidence. And now in doing so, and in thinking about that consideration, the test that is important to determine whether or not a witness is in fact competent is to essentially ask the question, can this person understand the questions that are put to them? And can that person then formulate a response to that question that can be communicated to the court such that the court understands them? And the test for whether or not this is whether or not a person is in fact competent is a test that the party bringing that witness has the burden to show, and it is also a test that is determined on a standard of balance of probabilities. Now, we noted in the previous lesson that the thing that is very important about these kinds of cases, and what is often raised when thinking about these kinds of cases, is the extent to which children are able to give evidence and testify in court, the extent to which children are able to be competent witnesses. Now, this lesson is going to explore this in more detail in this video. So we'll talk about the various different specificities required for children when it comes to witnessing and being witnesses and the questioning of their competence. And it's important to begin by just raising the fact that it is important when thinking about considerations for children. They are most often the question of witness competence in the course of a criminal trial. And so as such, much ink has in fact been spent discussing these circumstances, especially by judges in courts and through the development of the common law, which may or may not be considered competent, i.e. the circumstances in which children may or may not be considered competent. And additionally to the previous legislation that we explored in the last lesson, we thought about Section 53 of the Youth Justice and Criminal Evidence Act. Now, Section 54 is also important because it says, quote, any question whether a witness in criminal proceedings is competent to give evidence in the proceedings, whether raised by a party to the proceedings or by the court of its own motion, it is for the party calling the witness to satisfy the court that on balance of probabilities, the witness is competent to give evidence in the proceedings. We noted that in the previous video, if you remember. We explored this at the end of the last lesson, that essentially if either the party or the court is going to raise a question of competence, it is up to the party that is bringing that witness to court to show on balance of probabilities that they are in fact competent to give evidence. Now, in determining the question mentioned in subsection 1, the court shall determine the witness as having the benefit of any directions under section 19 which the court has given or proposes to give in relation to a witness. Any proceedings held for the determination of the question shall take place in the absence of a jury, if there is one. So essentially what we're thinking about here is if we're talking about jury trials, and the proceedings need to be put in place as to whether or not an individual is competent to give evidence, the proceedings held for that determination will be done absent a jury. It's a determination that is made by the court. It's not a determination that is made by a jury. So a jury doesn't need to see or have any kind of input in that. And you can also see that there may be expert evidence received on the question. So they might want to bring in an expert testimony to provide evidence for why or why not an individual is competent to give evidence. This might be in the case of somebody who maybe is a psychiatrist or a psychologist who is thinking about a person who maybe has learning difficulties or maybe is disabled in some way or even has experienced some kind of trauma. And so the question of their ability to answer questions and to make determinations and understand questions might be a question that is raised on the account of the expert evidence. So an expert might want to come in and receive and impart testimony on that question. Any questioning of the witness, where the court considers that necessary, shall be conducted by the court in the presence of the parties. So if, for example, we are challenging an individual's witness, we're saying that this person is not competent, they need to provide evidence that they are, they might ask the courts might just ask the witness if they're competent, or maybe make a determination on the basis of speaking to the witness and questioning the witness if the court considers that that is necessary. Maybe the court can just spend a bit of time questioning the witness to see if they are able to understand questions put to them and understand how to answer those questions, and then make a determination on that basis that on balance of probabilities they are probably competent to give evidence. In such a circumstance where that may take place, that kind of questioning is conducted by the court in the presence of the parties. So the parties are there, defense and prosecution are there, but it's not the defense and prosecution that are doing that questioning, it is the court that will do that questioning. Now, for children and in children cases, there are additional considerations as per Lord Judge from the case of Barker in 2010. Ultimately, these are the kinds of things that are important to realize when thinking about children cases, just as a way of expediting the process of giving evidence or to minimize the impact that this might have on a particular child witness. So essentially, the competence of children in providing evidence, it might be the case that the courts should not determine whether or not the age of a witness can be constructive to whether or not they are able to give evidence. So essentially, as I mentioned in the previous lesson, that ultimately the age of a witness might correlate with their ability to answer questions and to receive and to understand questions, but it is not causative. It is not the case that the age of a witness is determinative in thinking about whether or not they can give evidence. Okay, so a child could be 3, and that child might be able to give evidence, whereas a child who is 5 might not be able to give evidence, because it's not about whether or not they're 3 years old or 5 years old or whatever. It's about whether or not they can understand questions and have them and to formulate answers. Age is also not determinative as to the accuracy of the evidence given. So you can't, for example, challenge the accuracy of the evidence because it was evidence that was given by a 3-year-old, okay? That you can challenge the accuracy of the evidence on the basis of maybe it not lining up with the determinative facts that we've seen in other circumstances. Let's say we get witness testimony of multiple people. One person says one thing and a child says another thing. You might want to challenge the accuracy of what the child says on that basis, but you can't say, well, they're 3 years old, so their evidence is not accurate. We should give it less consideration than somebody who is older because they are so young. That's not something that you can do either. It is not determinative of the accuracy. The issue of competence may be raised even after the child has given evidence. This is a very important point, because if you remember to the previous lesson, there is a presumption of competence. And so if nobody challenges it, if nobody rebuts that presumption, then the presumption of competence will just continue, and that child will testify, and that child will be questioned like they are a witness, as the case may be. And it might be the case that once this testimony has been given, that somebody wants to raise the question of whether or not they were even competent to give evidence in the first place, because maybe it didn't go the way that people expected it to go. Maybe they didn't raise any alarm at the time, but they probably should have done. And if that's the case, then you can raise the issue of competence even after the child has given evidence. Also, the question of competence should be case-specific, and it must be determined in each case, rather than necessarily applying a broad criteria on the basis of age. And Lord Judge in this part, in this case, makes a very important point that judges shouldn't be applying their preconceived biases against certain witnesses in cases on the basis that they have dealt with children, for example, of that age before who were deemed to be not competent. So let's say there's a 5-year-old that's going to give evidence. If the judge is also a judge who has presided over a case involving a similar aged individual, someone who maybe was also 5 years old, who were deemed to be not competent to give evidence, They can't take that preconceived bias into this new case. It should be case specific. It should be done on a case by case basis. It is not the case that we should make determinations about competence on the basis of all children of the age of 5. It is about whether or not we can make a determination on the basis of competence for this individual child in this individual case. And then finally, from the case of Maliki from 2009, an additional point needs to be made that cases involving such young complainants must also be fast-tracked. So there is a sort of a speed impediment that is necessary for thinking, or speed imperative, should I say, that is necessary for thinking about these kinds of cases as well.